Many thanks, Professor Kogan. Indeed, my name is Jonathan Brosseau. I'm a PhD candidate at McGill. I'm doing my thesis with Professor Andrea Björklund at McGill and under the supervision of Professor Mathias Audi at Université Paris 1 Panthéon-Sorbonne. So today my presentation has three parts. In the first part, I'll present my main argument, which is that civil procedure principles giving effect to state immunity emerged from transnational law. Second, I'll use the example of service of process to illustrate this argument. And third, I'll explain how this argument builds on a literature review on civil procedure principles. So first, my argument. And I'll begin with a reminder. The doctrine of state immunity shields foreign states from civil lawsuits initiated by private parties in the national courts of forum states, so the states where the suits are brought, bearing specific exceptions related to the commercial activity of foreign states. And the civil procedure principles that I mentioned govern the procedural conduct of these lawsuits, regulating issues such as how does a private party serve judicial documents initiating proceeding against a foreign state, or to take another example, when can a national court issue a default judgment against a foreign state in case of its non-appearance? So I have a few jokes about state immunity throughout my presentation. Please don't judge me. I'll begin with my argument, which is that civil procedure principles giving effect to state immunity emerge from transnational law and should be further developed through transnational law as both an approach to transnational legal problems and as a body of law proper. I'll explain. And to begin with, I use the definition of transnational law that was coined by Professor Jessup in the 1950s as all laws which regulates action or event that transcend national frontiers. Both public and private international law are included, and so are other rules which do not wholly fit into such standard categories. So, in other words, my argument is that the principles addressing civil procedure issues that arise in state immunity disputes must give effect, sometimes concurrently and sometimes even simultaneously, to rights and obligations under different bodies of law. I also argue that the transnational law approach is the most nuanced and comprehensive one to identify and refine these principles. It's a big argument. I'll give an example to explain what that means concretely. So moving on to part two, I'll use the example of service of process to make this a little bit less abstract. And again, service of process is how should a private party serve judicial documents initiating proceedings against a foreign state. Let's take a specific situation. So many forum states have signed the 1965 Hague Service Convention, an international treaty, and must require private parties to serve foreign states through this convention under public international law. However, any waiver of service of process is governed by the national law chosen in the agreement between the foreign state and the private party, an other rule in Professor Jessup's parlance. And still, the effect of the waiver is subject to the civil procedure rules of the forum state under its national law, which partly derive from private international law. But even more complicated still, these rules on civil procedure under national law that give effect to the waiver and under this the Hague Service Convention, well, they must give effect themselves to three different bodies of law. First, the right of sovereign immunity of the foreign state under the relevant national state immunity law and customary international law. Second, the right to a fair trial and property of the private party under international human rights law, and to a certain degree, administrative and constitutional law. And third, the right of the forum state to determine its diplomatic and foreign relations under general public international law and constitutional law. So we see quite a few bodies of law that apply to a single issue in a dispute, and sometimes even simultaneously, because, for instance, you can have a service process rule that could be challenged by a private party on constitutional grounds or administrative grounds. And at the same time, so there's very much different bodies of law that are applicable here, which is why I refer not to civil procedure rules, but principles that derive from all these rights. So concretely, what I argue is that if a foreign state has no explicit rule on service, its court should exercise their discretion, their judicial discretions, to require the private party to serve the foreign state while respecting these principles that give effect to the different bodies of applicable law I've just mentioned: public international law, private international law, and transnational law. Transnational law, which is mostly composed of private law, but in certain instances, transnational law can itself be a body of law. And I'll give an example on state immunity, where the US Supreme Court, in the landmark Bansek decision on the piercing of the sovereign veil, determined that it had to apply the principles of equity common to international law and US federal common law. But so this is if a state has no explicit rules on service. If a state has rules on service and they don't respect those principles, I argue that the state should revise its rules. So certainly it'd be much easier if state agreed to an international convention that took into account these different bodies of rights and obligations that operate at different level of normativity. And if they made so in specific and binding terms, laying them out as proper rules with a capital R, that would increase legal certainty and predictability for all affected parties. But I'm not one of those PhD candidates who recommends that only an international convention could solve the problem that he or she identifies in his or her thesis. My broader point is more conceptual, that the rules that are applied to serve, for instance, a foreign state should respect these different bodies of law. Sometimes that applies to an issue, sometimes concurrently, and sometimes even simultaneously on the same issue. And I move on to part 3, and it's to explain how these principles build on a literature review I've conducted for my research. And it's interesting because there's a relatively limited literature on civil procedure rules or principles that relate to state immunity, so on rules on service, default judgment, and it has largely been forgotten throughout the 19th and 20th centuries. And in fact, three authors that I've surveyed in this literature out of maybe 15, which is not a lot, have been at some point president of ISIL. So Philip Jessup, Peter Troboff, and John Stevenson. So that means that my chances of becoming president of ISIL are still of 0. So I'll present very briefly this literature, focusing on some of the seminal points that have been made, and to set out 3 points that support my argument. And they're as follows. So first, civil procedure principles related to state immunities. Some of them have already been formulated on service, on issues such as third-party debt order, when a state creditor is trying to obtain, especially as an interim measure, an order against a foreign state that to try to go around some of the non-availability of interim measures by targeting not the assets of the state, but the assets of the state that are in the hand of a third party who's trying to pay back the state. Well, these principles have not yet been formulated. So that's part of my task to, on the case of service, criticize the rules that exist, to explain whether, in most cases, they don't respect the principles I've highlighted, and don't give effect to these different rights under public international, private international, and transnational law. In the case of third-party debt orders, to come up with some more defined rules, so to speak, on these issues. And the second is that these rules, existing and proposed, are very much part of the state immunity doctrine, which is not so much the view of the literature in the later part of the 20th century, so much so that they determine the outcome of cases much more than exceptions to state immunity in practice. And the third point, it is that it's possible to discern common functions to civil procedure principles across jurisdictions and sometimes within the same jurisdiction. So how do I summarize 150 years of scholarship in 2 minutes? Well, certainly I'll make some over-characterization, and by saying that at the end of the 19th century and early 20th century, it was very much the private international law approach to state immunity and to the rules of civil procedure that gave effect to state immunity that was prominent. From the middle of the 20th century to today, the state immunity literature much more focuses on public international law. And in the US, since the 1990s, the transnational law approach has been more prominent. I'll review very briefly some of this literature to highlight these points. And beginning by the resolution of the Institut Droit International in 1891, so more than a century ago, that very much looked into those civil procedure rules and even enacted and proposed a rule on service of process. And this makes sense because at the time, the rapporteur of this Institut Droit International resolution was a German professor, Ludwig von Baer, who was a private international lawyer who wrote a great chapter on these civil procedure principles in his own private international law treaties. But this approach has lost prominence to the point that a recent bibliography on state immunity of more than 20 pages simply notes that the topic of state immunity is also looked at in private international law treaties. The public international approach. Well, I mentioned Professor Philip Jessup drafted an international treaty on state immunity rules, known as the Harvard Draft Convention, which featured several provisions on civil procedure rules. But this approach and this focus on civil procedure rules certainly lost prominence, and I believe that one of the reasons why is because Sampol Sucharidkul, who wrote an influential book on state immunity in the 1990s, that did not cover civil procedure rules, then became the special rapporteur of the ILC on state immunity, which led to the enactment of the 2004 Convention on State Immunity. And he didn't believe that they very much were part of the state immunity doctrine, which is why the last draft of, in the eighth and last draft of the special rapporteur report, that these rules were introduced, and they became known as Article 22 of the service of process, Article 23 on default judgment, and 24 on non-procedural sanction against non-compliant states, under the very uninspiring heading of miscellaneous provisions. And these actually don't really regulate those civil procedure issues. They kind of refer to domestic law processes. And when I mentioned that this literature has largely been forgotten is because Peter Trubov in the 1980s wrote a great Egg Academy lecture on the topic of state immunity, and his final proposal is to make a convention not on exceptions to immunity, but on civil procedure rules. And same thing, James Crawford, when he made his report on state immunity for the Law Commission of Australia, reviewed civil procedure rules, but both of them did not discuss this earlier literature, seemingly being unaware of it. And it's not to criticize them that I note this, but because they're certainly more eminent jurists than I can ever wish to be, but simply to show that this literature has not been systematized. Very quickly on the transnational law approach since the 1990s, there's been a renewed interest for these rules, including in the US, that for scholars of the field of transnational civil litigation, but this literature is certainly not comparative. And one example I'll give of that is it's the book that is widely seen as launching this field of transnational civil litigation in the US is the 1989 book by Gary Bourne and David Weston, International Civil Litigation in the US. And actually, a lot of the principles from this book that make up civil litigation, transnational civil litigation as a field have been taken on by the German-speaking literature for almost a century, but this is never mentioned. And the first book in the US literature that is seen as creating this field of transnational civil litigation is David Weston and Gary Bourne's book. So that was brief. I hope I managed to convince you that civil procedure rules giving effect to state immunity emerged from transnational law. And I thank the organizer for inviting me to this fantastic event. Thank you.